Good afternoon, everyone. Welcome to today's installation of the Research Skills series here at the University of the West Indies Faculty of Law, the St. Augustine campus. Thank you all for joining us today as we have an esteemed speaker who will be speaking to us on researching transitional justice. Professor Colleen Murphy is an expert in this field, so I'm going to let her introduce herself and her topic, and hope we all have a very productive session. If you have any questions during the seminar, you can feel free to type in the chat or raise your hand. If it's in the chat, I will be monitoring it, so I will let Professor Murphy know your questions. So Professor Murphy, over to you.
Thanks so much, Emma, for the invitation, and to all of you for being here. I'm, as was mentioned, a professor in the College of Law at the University of Illinois, Urbana-Champaign. I have appointments in the philosophy department and political science department, and direct a program called Women and Gender in Global Perspectives. My research is on the subject for today, transitional justice. And so one of the things that was really nice was to have an occasion to think about how one goes about doing research, because that's not really a question that we reflect on or think about that often. And so I will be sharing some slides in the beginning, and then I will remove the shared screen. But as was mentioned, any questions you have, feel free to stop me at any time. And also I'll welcome questions at the end. So let us go ahead and get started. Okay, so the outline for what I want to talk about with you is as follows. I first want to just explain what transitional justice is. I know it's not familiar to everyone, so I like to start there. Then talk about the plural research methodologies that you find in scholarship on transitional justice. And then talk a little bit about where is this research used, for what purposes, and how is it disseminated. Okay, so what am I talking about when I'm talking about transitional justice? The simplest way to start is with the guidance note of the Secretary General of the UN from 2010, in which transitional justice is defined as the full range of processes and mechanisms associated with a society's attempt to come to terms with a legacy of large-scale past abuses in order to ensure accountability, serve justice, and achieve reconciliation. So the definition is helpful both for what it captures and for kind of areas of debate to which it points. So at its broadest level, transitional justice is concerned with redressing, as the UN says, large-scale, I'll omit the past because it could be past or present, but large-scale abuses, widespread violations of human rights that can constitute war crimes or crimes against humanity in some cases, or even genocide. And where the starting point for discussion within transitional justice scholarship is a presumption in favor of reckoning with wrongdoing for both instrumental and non-instrumental reasons. Instrumentally, out of a conviction that efforts to simply move forward, to move beyond legacy periods of abuse, either bound up with conflict or repression or more systemic, or setting aside wrongdoing, won't actually enable communities to move on, but rather sets the conditions for either recurrence or continuance of abuses. And then non-instrumentally, that abuses and violations of human rights generate claims that victims have and survivors have, which are important to satisfy for their own sake. Which abuses we're talking about is the subject of discussion. There was, as we'll see in a moment, when I give you kind of a genealogy of the field, an initial emphasis on civil and political rights that's expanded to talk about economic rights, and even more broadly, issues of structural injustice and historical injustice bound up with colonialism and legacies of colonialism, transatlantic slavery and enslavement and their legacies as well. So not only is there a presumption in favor of redress, but also a shared set of basic diagnostics about what is it that enables abuses to become widespread, what makes that possible. And where one condition that's recognized is impunity. And that's the subject of a lot of discussion, where impunity, the ability to do abuse or commit abuse and get away with it, is taken to necessarily implicate government institutions, both at the national and increasingly discussion around the international level, and where part of what is behind impunity could be that state actors are the ones who are perpetrators of abuses. But even when that's not the case, that there are various reasons why perpetrators are not held to account, and why patterns of abuse are maintained. In addition, recognition that abuses that are focused on are linked in really important ways and profoundly with broader problems of structural inequality and injustice in the ways that political relations are set up, and where kind of the goals as part of the UN indicates is trying to both satisfy basic claims of victims, meet moral demands of accountability for perpetrators, and more broadly try to transform the ways in which individuals interact and relate. The language of reconciliation is fraught and often controversial when it's invoked, though it's invoked quite frequently. And processes are wide-ranging, anything from criminal trials domestically, internationally. You have some with the ICC or ad hoc tribunals like the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda. You have truth commissions, you have reparations programs, you have lustration programs where individuals who are barred from serving in certain public capacities unless they reveal linkages and ties they have with, for example, the secret police in a prior regime. Constitutional reform, memorials, art, and also a lot of locally specific and indigenous ways of dealing with wrongdoing. Okay. Transitional justice is an evolving field of scholarship and practice. One genealogy of transitional justice that is commonly referred to is offered by Rudy Teitel and then expanded upon by Dustin Sharp, where the origins are traced back to post-World War II and the Nuremberg and Tokyo trials, which were predicated on interstate cooperation for redressing abuses and utilized criminal trials. That was followed in what's often called the third wave of democratization between the 1970s and 1990s, with more localized pursuit of transitional justice, often in discussion around South America's efforts, and efforts in Central and Eastern Europe post-fall of the Soviet Union, where there's a lot of emphasis on kind of rule of law objectives, and where you see extensive use of truth commissions. So those are ad hoc official bodies established and charged with a mandate of investigating and documenting certain patterns of wrongdoing, often also with an eye to identifying what are the root causes and what are the consequences of violations that occurred. In many cases, commissions often offer recommendations for non-recurrence as well. Then you see starting in the 1990s, a third phase where you see transitional justice moving as something that's exceptional, that's adopted in periods of exceptional change, to becoming a more basic norm for rule of law governance, and a return to the use of trials, and some examples of where that has happened. And a phase 4, Dustin Sharp argues, starting roughly around the 2000s, where you see increasing pushes to extend the context in which transitional justice is used, no longer solely as part of an explicit process of moving from conflict to post-conflict, or from autocracy or repression to democracy, but for dealing with legacies bound up with settler colonial contexts, reckoning transnationally with legacies of and claims around colonialism, a greater emphasis on economic injustice and prioritization of those sorts of wrongs, and emphasis on local agency in both decision-making and processes. So what kinds of investigations do you find within the scholarship? They're wide-ranging and broad, and I'll just talk about 4 different types of methods that are used, that I define as normative and conceptual, doctrinal, empirical, and critical. And where in each case, I'll be talking about kind of what are the questions that are examined, how are they answered, what are the kinds of criticisms or objections that are raised, and then talk briefly about some ongoing challenges in terms of research and scholarship. So the first kind of method is what I call normative and conceptual. And so what is fundamentally of interest there is answering the question, not how do societies respond or not to large-scale abuses, but how should societies respond to large-scale abuses, and where part of what's framing those conversations that try to answer that question is implicitly a presumption in favor of punishment, or sense that dealing with egregious wrongdoing requires trial and punishment of perpetrators of wrongdoing for both basic reasons of justice, for deterrence reasons. If you want to prevent recurrence, you need to have this, from a conviction that that is important for vindicating the rights and dignity of victims. And yet, despite all of that, in fact, punishment is not the most common tool that is utilized to redress legacies. Amnesty, where you are removing the prospects of civil or criminal liability, remains extensively common. And there are recognized limits with trials, especially in contexts of widespread abuse, that if the only thing you do is put people and a few people on trial, that may end up reinforcing either collective or societal, as well as governmental, denial about the roles of other actors beyond the most immediate and direct perpetrators in enabling and contributing to abuse. So kind of worries about scapegoating, that the problem was really these few bad apples, and now that we put them behind the bars, everything that we need to deal with is taken care of. That trials, I'm going to actually stop sharing for a moment just so I can see some of you, that trials are recognized to be often a poor platform for victims, in the ways in which they are predicated on adversarial forms of confronting the sorts of claims victims want to make. And not all victims want trials or see that as a priority for them when it comes to satisfying claims of justice. There are access to justice limitations in terms of the distance of courts with respect to the communities dealing with legacies of wrongdoing. Some courts have linguistic barriers to the proceedings, so the ICTY, the languages in which proceedings were conducted and judgments were issued were not in the languages that were widely spoken within the countries that constituted the former Yugoslavia. Effective investigations can often be obstructed by governmental actors who aren't interested in seeing accountability, by difficulties in getting witnesses to testify out of their own security concerns and skepticism about what the trials will bring about. There are important critiques around selectivity and who's put on trial. You see a lot of that with respect to the ICC, the International Criminal Court, which until recently had all and only African defendants in African cases that were taken up. Trials are expensive and they're lengthy, and so may not be well suited to meet the more immediate demands of societies grappling with these legacies. And so if not trials, then what? In thinking about how should societies respond to the aftermath of abuse. And so you see analyses of what is the moral point? What are we trying to do in responding to wrongdoing? And how might processes other than trials potentially give us progress towards meeting those goals, where you see appeal to recognition of the dignity of victims, accountability demands, rebuilding trust, appeals to in strengthening democratically oriented institutions, appeals to the rule of law, among others, mitigating poverty, mitigating inequality. So kind of what are we trying to do? How should we think about the very real and profound constraints in which efforts to undertake redressing legacies of or more immediate periods of abuses that those decisions are made under, constraints that are both economic in orientation, political in orientation. You're often dealing with extremely fragile and deeply divided political contexts. Temporal in tensions between short-term immediate goals and longer-term aims and aspirations. And so in this space, you see a lot of discussions of compromise, what compromises are defensible, which ones are not, restorative justice oriented accounts, transformative justice accounts, among others, and then objections to accounts that are advanced that they claim to be universal, but in fact are not, that they are reflective of the priorities or commitments of specific contexts, but not all contexts, that they involve sort of neo-imperial imposition of goals in ways that are morally problematic. A lot of debates around who should be the one deciding, both within communities and more globally, the answer to the question of how should wide-scale abuses be dealt with. So that's kind of the first category of what I've called normative and conceptual. The second category is what I called doctrinal. So this is where a lot of legal scholarship fits in, but by no means the only place legal scholarship fits in, but where the interest is in answering questions like, insofar as amnesty is frequently adopted, Louise Malinder at Queen's University Belfast has a comprehensive database of the hundreds of amnesties that have been passed over recent decades. So insofar as we see this, when and to what extent and under what conditions are amnesties permissible under international law? Where part of the debate is around what are state obligations with respect to dealing with violations of international law. Is there a duty to investigate? Is the duty to prosecute and punish? What kind of pluralism is compatible with state responsibilities? And here, kind of the ways in which the International Criminal Court operates in preliminary investigations often is the site of conversations and a lot. I can talk in Q&A of interest with respect to Colombia in that context. There's doctrinal clarification. So insofar as the UN provides guidance and basic principles with respect to the rights of victims to reparation and remedy, what does that mean specifically and more concretely as established by customary practice or case law? How do we unpack the claims that are made about what is needed? And then explorations of possibilities and limits. So how does the structure, for example, of international law inhibit or facilitate accountability? One important discussion site there is with respect to corporate accountability and looking at possibilities for accountability for the roles that corporations, multinational corporations in particular, play in human rights violations within the confines of what international law incentivizes, prohibits, etc. How these arguments are made and are in kind of looking at case law and legal materials. And then objections are both internal to particular discussions, so debates around whether there is or is not a duty to prosecute as opposed to a duty to investigate, and then broader critiques within the context of, for example, TWAIL literature and scholarship, so third world approaches to international law, that I'm going to talk about in more detail when I get to the critical strands of scholarship in transitional justice in a minute. Before I turn to that, let me say something really briefly about empirical scholarship, which is another kind of set of conversations that you find that are really concentrated around understanding what explains what happens and why in particular contexts, what choices are made with respect to which wrongs and legacies of abuses, what processes or process will be implemented, and then also what happens, what are the effects, what changes or doesn't change as a result of the processes that are put in place. And so kind of given the widespread variation in how communities globally do deal with widespread abuses, how do we understand which actors are most critical for the process? If you want to establish a truth commission, for example, whose activity is most central? So is this a domestic politics story where what matters is elites, political elites? Is it a domestic politics story, but more grounded in the role of civil society and grassroots social movements? Is this an international politics story where you've got the role that or interest of international NGOs or international pressure explaining? Is it both? And how does that interaction look like? What is the way in which context explains choices? So whether you're dealing with a context of a negotiated settlement where both sides that were in conflict continue to have power, as opposed to the vanquishing of one particular kind of one side in conflict. To what extent are there and how pervasive are there when it comes to spoilers? Spoilers with respect to those who are not interested in and are adamantly opposed to any kind of process dealing with legacies of wrongdoing, or to other sorts of institutional or regime transitions that are taking place. How does the legacy of abuse itself, what it looked like, shape choices? And then finally, kind of in the aftermath, about impact. So what happens? Does anything change? Are victims satisfied? Has the rule of law been affected? Are there differences in trust that you find? And where you see in all of these questions different types of investigation. Some are very quantitative, looking for correlations in taking a large data set of kind of instances in which there has been a trial, for example, and to what extent is that correlated with the absence of resumption of conflict or reduction in levels of killing. Quantitative exercises that are, or analyses that are grounded in survey data that's set out. And those surveys, as well as kind of more ethnographic work that's trying to get qualitative information to understand the perspectives and experiences of members of the community about which we might have quantitative data, as well as historical and archival research to understand kind of what are the arguments that were being advanced and might have made a difference in the legislation that resulted, and where investigations are objections can be in terms of whether or not there's sufficient data to draw the conclusions that an author is advancing, whether the right kind of data is being collected to justify an inference that's being made, about the extent to which you can extrapolate from the experiences of one context and make any kind of implications for other sorts of contexts. So that's the third. And then the fourth, and I recognize the time is, I want to make sure that there's time for questions. So I'll try to move quickly through the remainder. A really important emerging fourth strand of scholarship is what I call critical, and critical in different ways. So one kind of strand is in terms of pointing to conceptual limitations with both the practice and the scholarship. Limitations in the ways in which issues of race are or are not prioritized, recognized, and adequately dealt with. In the narratives that emerge as a result of the processes that are established, and in particular, the failure to sufficiently historically situate particular periods of abuses that are investigated against the background. For example, often this comes up in the failure to situate episodes post-independence of abuses with the roots that they have in colonialism and the legacies of colonialism. In limiting investigations or processes within the confines of a nation state, when both the explanation and character of conflict or repression is often profoundly transnational in terms of not only multinational corporations, but actors and who are perpetrators of wrongdoing, third countries supporting abuses that are occurring, the ways in which there's transnational dimensions to the victims who ought to be participants, given the ways in which often large diaspora communities are bound up with, the ways in which they're created are bound up with periods of abuse, as well as critiques around the emphasis on national and international efforts in a way that erases more local, subnational, and more indigenous resources, processes, and activities. A second kind of strand is in sort of assumptions that are made that are seen to be insufficiently defended. So the idea that transitional justice can be transformative, do we have any evidence that that actually is in fact the case? Must societies redress wrongdoing or address wrongdoing? And what is the kind of sequencing within which that must happen? So Spain is often advanced as a counterexample to the idea that immediately following, in that case, the falling of a decades-long dictatorship necessitates an immediate inquiry into abuses of the past. Does public discussion and public processes, are they actually healing and cathartic for victims in ways that are talked about, or are they instead traumatic, re-traumatizing? And to what extent is there variation just in the responses of victims to them? In the disproportionate focus on law, so legalism as an important critique, because of the ways that law and legal perspectives can be limiting by virtue of the categories that law works with, the ways in which victims cannot exercise a certain kind of agency in defining wrongdoing in their own terms, but have to fit them within categories law recognizes, the ways in which criminal trials end up being emphasized more than they should. And then two more critiques kind of around the ways in which the international legal order and international order more generally are treated. So rather than being providing the standard against which we measure the adequacy of domestic efforts, shouldn't the international order itself be the site of scrutiny and the site of calls for more radical reform? So looking at, whose interests are furthered by the ways in which international law is set up, which victims get recognized, how the global north and global south are situated with respect to expertise. So often in practice, it's global north based practitioners or academics going to global south based contexts of abuses, but instead the argument is, and based on just kind of where transitional justice experiences and expertise lies, the direction ought to be inverted, that the expertise lies in the global south and it is the global north in need of more systematic attention to redressing legacies of abuse. And then, so questions for exploration are around all of these critical strands of scholarship, and I think fundamentally around kind of thinking about what is success in the short term and after and long term for any kind of process dealing with a legacy of abuse that outstrips the capacity of any one effort to be able to adequately reckon with. And in addition, I'm the co-editor-in-chief of the International Journal of Transitional Justice, and one of the things that we're talking about is around questions of language justice, around questions of authorship, and trying to balance the expertise that practitioners, folks on the ground, social activists have with academic expertise, and recognizing the different sources of epistemic bases of knowledge that actors of different kinds bring. Scholarship is disseminated in a wide range of in academic forums, so journals from law reviews in political science, psychology, so kind of field specific, as well as interdisciplinary journals like the International Journal of Transitional Justice. It's disseminated in advocacy campaigns to draw attention to and awareness of abuses occurring in different places, to inform calls for institutional design when it comes to a particular process, or institutional critiques, and just kind of the purposes of research are for basic kind of demands of justice, of giving voice to, for example, victims and their experiences. You find the kind of scholarship and advocacy and institutional policy purposes reflected in the venues of publications. So you've got country reports coming from the UN Special Rapporteur for Truth, Justice, Reparation, and Non-Recurrence. You have blogs, you have journals. I guess I'll stop there, but many forums for disseminating research, and look forward to questions or comments that you might have.
Thank you very much for that, Professor Murphy. I think that was very informative. Students, this is your opportunity to ask questions. So you can either put up your hand or you can type in the chat. And while you're thinking of your questions, let me draw some connections to what you all have studied before. So we heard Professor Murphy use the terminology of imposition. You'll remember in law and legal systems, when you're looking at how the Caribbean got their legal systems, we know that it is through the legacy of colonialism. We talked a lot about how we can be agents of change by using laws to aid in our own development. Now, this imposition term still applies within this field of transitional justice when we are looking at foreign goals and trying to reconcile these goals with development within the region. And those of you who are doing the Human Rights Clinic this semester, if you are selected for the course, because I know there's an essay component to get on the course because there is the cap due to space issues, I think you will see that this is all very much what you will be doing within this course in terms of looking at these large-scale abuses. Not sure exactly what the project is as yet, but it tends to be a present large-scale abuse that is examined. And the way in which these abuses are addressed are very much relevant in the Human Rights Clinic course. And of course, if you've done international human rights studies at any point, everything here, while it might not be what you have covered directly, because this is a whole specialized field, it does relate to the type of inquiries you have undertaken in these courses. We are very fortunate to have somebody who's an expert in transitional justice talk to us today. So please don't miss this opportunity. Now is your time to ask questions. So I'll give a moment for anyone who would like to ask their questions, either in the chat or you can raise your hand.
And while you all are thinking of questions, I'll just add on to a couple of things that you were just saying now that I think one is there's a lot of discussion around the relationship between transitional justice and development. Tensions between donor goals and objectives of transitional justice processes around this question of measurement I indicated at the end. So if donors want to see results immediately, but the kind of impact a process for dealing with wrongdoing might or might not have is not as evident immediately, or might be longer term, or might be setting the conditions for future change. How do you deal then tensions between what those who are funding processes want to see and what's needed to repair abuses, and the ways in which development goals and objectives and redressing abuses might pull in different directions in terms of priorities and objectives. I should also say anyone is welcome to reach out to me at any point if you have particular questions or want suggestions for references or scholarship. I'm always happy to provide that.
So I have a question that I'm sure the students are
Sure,
thinking of, but sometimes they're a little shy to ask.
that's fine. Yeah.
So how would you suggest going about getting involved in this field? Because we do have a great need for transitional justice within the region, but sometimes it can be difficult for students to figure out, like, how do I start something like this? And I'm trying to, get through my undergrad law degree, and I need to figure out what do I do next? I want to make a difference, but I'm not sure how I go about that. What do you suggest?
So I think there's kind of a different a range of so I guess the first thing is there's no one single path to getting involved. The second thing is by virtue of studying law, which I assume is the field, the degree that's being pursued, you are already well positioned to engage in transitional justice because of the fact that transitional justice is dominated by lawyers. Not everyone is happy about that fact, but it is a fact, along with other scholars of different fields. And one of the ways in which legal scholars or legally trained graduates bring invaluable knowledge is in these questions around institutional design. How are you, if you're going to pass legislation or you're going to pass something that's designed to establish a commission of inquiry, how you do that well, what you need to be cognizant of in terms of the constraints sent by your own domestic legal order and, as I was talking about earlier, international law. And I guess another thing to say is that there are ways in which you can be engaging and or contributing to transitional justice that aren't even necessarily what your day job looks like, but by virtue of advocacy or dealing with your own local community. So often when I'm teaching transitional justice to my students who are not necessarily in the United States, you don't study law as an undergrad. So for the undergrads that I teach, they are in a whole host of fields from across campus. And even for my law students, they might be going to work in fields that are far away from transitional justice, but kind of digging into the history of the particular city or area that you come from. So in the context of digging into our own history in the US, in thinking about, for example, where the Ku Klux Klan operated and how that was extensively, it's often for Northern students that I teach, a presumption that it's the South that was racist and the North, we were okay. But then you dig into your own history of place and see where documenting where lynchings were known to have occurred locally, or looking at issues around voting and access to voting rights, the ways in which economic inequality and how that's bound up with legacies of redlining, of preventing African Americans from accessing credit and getting mortgage loans from banking, has intergenerational consequences in terms of wealth. So there can be ways in which you look at your own place and try to bring to light and make more visible the history of the very local and specific place that you are from, even if it's not kind of more national. So a range of ways. Again, there are developing networks. So again, you should feel free to reach out, and if you have more specific questions, but many different pathways is the main takeaway.
Thank you so much for that, Colleen. I think that's really useful for people to realize, start within your own community. It's not, you don't have to look that far to find injustices, unfortunately. So start within your own community and be an advocate for your community. And especially as you are all given the benefit of this legal education, we have a generation now that has much greater access to education than your parents would have had. So you are in a position to make these types of changes for long-term justice to be served. It might not be something easy, but I know many of you are passionate about human rights and regional development. So you should feel empowered knowing that while perhaps it's not favored that the field is dominated by people with a legal background, you do have that background, so you
Yeah.
will be able to enter into this arena. So,
If I
final call for questions. Oh, Colleen, yes,
Yep.
sorry.
No, I just want to say one thing on the end, because I don't want to knock lawyers. I think that the takeaway
Yes,
is,
no,
yeah.
of course, of
But
course.
I think one thing that's really important to if cultivate in this space is an awareness that some of the folks, not only kind of in terms of thinking about clients you might represent, for example, but other scholars and practitioners are coming at the topic from a very different lens. And so being able to sort of translate what is driving your interests and concerns, and understand what are the kinds of questions other people might be interested in ways that could be complementary to, but different from what you're looking at, is really important. And I think makes this the kind of success of the very interdisciplinary, transnational conversations that happen occur much smoother and more in ways that are more fruitful.
Thank you very much for that, Colleen. I think that's some very sage advice. I see Anjali's hand is
Yeah.
raised. Anjali, go ahead. Anjali, I think you're still muted.
Sorry, my bad.
Okay, hearing you
I,
now.
sorry, I logged in with a link. So I'm Samantha, not Anjali. My
Oh,
bad.
sorry. Okay, thanks, Samantha.
My question was in respect to the global north.
Mm,
One of the points made was in respect to the global north needing to take notes from the global south in
yeah.
addressing justice towards victim minority groups.
Mm,
I'm wondering if there's like a real impact with those efforts, considering this recently the South Africa's case
yeah.
against Israel, where they had a very detailed list that says, yes, they do meet the requirements for their genocide in their war against the Palestine. And I'm thinking even with that very detailed list, I don't really, well, at least to my knowledge, understand if any real changes are being made. So I'd like some clarification on how
Good.
we
Good.
could really
Yep.
do things like that.
No, that's just a terrific question and a spot on example, right? Exactly. Especially in light of the International Court of Justice's court orders this morning. So I think kind of two different ways to respond. One is that part of the reason I framed that point in the context of critical strands is that it's coming from a place of scholars and practitioners who are dissatisfied with the existing impact, right? Of the marginalization of the knowledge that Global South communities and academics and practitioners have. And so partly it's a call for thinking about the kinds of reform that are needed in order for that to change and there to be an impact. So that's one aspect of a response to the question that you were raising. So for example, in the journal that I mentioned earlier, we're about to, or we will be in a period of time, adding a call for a new co-editor-in-chief. I just came on board, and also possibly other associate editors. We're talking right now, thinking through what the structure makes more sense, where the priority is on identifying and recruiting from experts in the Global South. And so it's around conversations of making connections and linkages. This journal has been connected historically to the Center for the Study of Violence and Reconciliation that's based in Johannesburg in South Africa. And so I was in South Africa earlier in the fall, and then our colleagues are coming to Boston and Chicago, or nearby Chicago, where I'm based, in the spring, partly in response to have conversations around this. So I think there is a need. So the short answer is to draw attention to this need is not to say that the need has been met or that the impact that should be present exists. At the same time, part of what's interesting around looking at discussion kind of very briefly on X, I guess it's called, and other forms of social media today, was around the ways in which advocacy, the impact not only for South Africa, but longer term legacies of what the International Court of Justice did today, and where there's a more optimistic note, cautionary, for this, speaking to the ways in which the Global South can drive needs for reckoning and stopping abuses when it's needed in the way that South Africa took the lead in this case. So kind of discussion and debate across a range of issues, but don't want to give the impression that the thought is that this is already existing. It's something that's demanded and called for and needed, and then questions of how much progress has been there. That's part of what's debated. So hopefully that answers or speaks to the question.
Yes, it does. Thanks.
Thank you for that, Colleen. So one more question. We have time for one more question if anybody has. Now is your opportunity.
Well, thank you
Yes.
all for being here. Yeah.
I think we have a lot to digest. Thank you very much for this, Colleen. It was very informative, very beneficial, and we really appreciate you sharing your expertise. And it's also really positive, the moves that are being taken with this journal to reach out to the Global South, because I do think these are the type of connections that need to be made to really have effective transitional justice. So
Yep.
it's very positive to hear that development, and really appreciate you giving your time and your expertise to us today. Thank you so much. And everyone, I hope you learned a lot, and I know you have a lot to think about.
Thanks so much again for having me here.
Thank you. Have a good day, everyone.